Hello everyone, and thank you so much for joining us this evening. My name is Nina, and I am a lawyer and project coordinator at the Community Legal Education Association, or CLEA. For those of you who aren't familiar with what we do at CLEA, we are a not-for-profit charitable organization, and our mission statement is unknown rights are not rights at all. We have been working to improve access to justice by providing information to Manitobans about their rights and the law. And we have been doing this since 1984. So this means that we are looking forward to celebrating our 40th anniversary in just a couple of years. Before we get started, we would like to acknowledge that CLEA's office is located on Treaty 1 territory, the traditional territory and ancestral lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the homeland of the Métis Nation. Our work extends throughout Treaties 2, 3, 4, and 5, and we further acknowledge that Northern Manitoba includes lands that were and are the ancestral lands of the Inuit. Today's webinar is a part of a series of webinars which we offer twice per year on a variety of topics. And today's topic is going to be criminal law with Michael Lazar. Just as a bit of housekeeping, today's presentation is being offered in webinar format. So this means everyone is muted and their cameras are off by default. We will have a dedicated time for questions at the end, but please feel free to ask questions during the course of the presentation as well by using the chat or Q&A functions in Zoom. And we will do our best to monitor those sections. As well, if there are any technical difficulties, please let us know using the chat function. I would now like to introduce our presenter and facilitator for the evening. So our presenter, Michael Lazar of Broadway Law Group, will provide a general overview of criminal law, including components of an offense, classes of an offense, defenses, the players in the criminal law system, the courts, processes, and sentencing. Michael Lazar has a Bachelor of Arts degree from the University of Manitoba and a Juris Doctor degree from New York University School of Law. He was admitted to the Bar of New York State in 1983 and the Manitoba Bar in 1984. After practicing law with Manley Israel and Associates and Pandya Davis Lazar and Bunov, Michael joined Broadway Law Group in March of 2000. Michael has served as a chair of the League for Human Rights, Vice President of Community Relations of the Winnipeg Jewish Community Council, Jewish Federation of Winnipeg, Vice President of the Rady Jewish Community Center, and as a founding board member of the Manitoba Ethnocultural Advocacy and Advisory Council. He has been a speaker for the City of Winnipeg Community Relations Committee and has lectured on criminal law for the Community Legal Education Association for many years. In 2003, Michael was awarded the Queen Elizabeth II Golden Jubilee Medal. Michael's preferred areas of practice include criminal law, child protection, family law, and real estate. As I mentioned, this evening, Michael will be covering various topics related to criminal law. So with all of that being said, it is my pleasure to turn it over to Michael.
Good evening, everybody. Today, we're going to be talking about criminal law, and we're going to give you basically the bones of the skeleton of the criminal law system. You have to understand there's a lot of meat that goes on those bones, little bit of interpretation. We can't do it all because, frankly, it's a 3-year course and we only have an hour and a half. But we will give you sort of the basics of it that will help you have a better idea of how the system functions, at least in Manitoba, and what the basics of criminal law are. So to start with, we're going to talk a little bit about what the sources of our criminal law here in Manitoba are. And there's 3 sources of criminal law, the 3 areas from which our criminal law comes from and is interpreted. And those sources are the Constitution, statutes, which are bills passed by Parliament, the legislature, the City Council, and then the common law, which is how judges over the years at different levels of court have interpreted the Constitution or the statutes. So let's start with the Constitution. The Constitution is basically there that gives authority to the government and grants them both powers and then limits their powers of government. The original Constitution of Canada is the British North America Act of 1867. That's an act of the British Parliament that created Canada and it divided up the powers of government between the federal government and the provincial governments as they then existed. And it's still, even though it's a century and a half or so later, it's still the part of our Constitution. Our Constitution consists of a number of different statutes passed both by the British Parliament and the Canadian Parliament, and signed by kings and queens as they come and gone. And together, these different acts make up the Constitution of the country, which, as I said before, sets out both the extent and the limits on government power and authority in Canada. So one of the things that about that's still existing from the British North America Act is the powers that it bestows on the federal and provincial governments in the creation of and enforcement of criminal law. So we have a situation in Canada where the powers of criminal law or relating to criminal law are divided between the federal government and the provincial government. The federal government is empowered by the BNA Act to create criminal law in the country, and the provinces are empowered to enforce the criminal law in the country. So oddly enough, you sometimes, because we have a democracy with different political views out there, you can have a situation where the federal government's creating a law that the provincial government that's charged with enforcing it may not particularly like or may not particularly agree with. And that has from time to time created friction between the two governments, two levels of government. Nonetheless, that's our system right now, is that criminal law, by and large, is created by the federal government and enforced by the provincial government. Now, of course, having said that, there's, as is going to be the case throughout everything I say, there's always exceptions. And for example, the provincial government creates its own laws that if you violate, they're punishable in a criminal justice context, such as the Highway Traffic Act. So if you go through a red light, or you're speeding faster than the prescribed speed, those violate, or you're driving without a license, those violate provincial legislation, the Highway Traffic Act of Manitoba. So how does that happen? Because you can get fined, you can even go to jail for short periods of time under provincial legislation. And if you are charged with a provincial offense, what happens in court happens very much, if not identically, to what happens with criminal code offenses. Criminal code, as we'll talk about in a moment, is from the federal government. Well, what the courts have decided is that the provincial governments have regulatory power. And of course, regulatory power doesn't mean anything if you can't punish someone for breaking the regulations. So they have limited power in regulating things such as highway traffic and the rules of the road, and they can impose punishments for violating those laws. However, the process of determining whether someone's guilty or not guilty of violating a provincial statute is largely, if not identical, to the criminal law process. You still have a right to have a lawyer. You have still the burden of proof, which we'll talk about, will still be on the prosecution to prove the offense, usually beyond a reasonable doubt, and so on. And by the way, that's true also of civic bylaw violations. You still get a chance to have your day in court when you spit on the sidewalk or violate some other city bylaw. So under the same rationale, the city has the power to regulate these things and therefore must have the power to punish violations of the regulations. So I said that the basic division of power comes from the British North America Act. The other big statute when it comes to criminal law, of course, is the Charter of Rights, which is part of the Constitution Act of 1982. And the Charter of Rights, which is only one part of that act, by the way, basically sets the limiting powers on government. It's the protection. It contains the protections for the average citizen against being charged with the criminal offenses and the other powers that government has. So it basically acts as limiting the power of the state in how they can prosecute individuals and by setting out and protecting certain individual rights. Some of those include the presumption of innocence, that the prosecution has to prove you guilty beyond a reasonable doubt. It includes the right to have a lawyer, includes the right to remain silent and not be forced to testify against yourself. It includes the right to have a trial within a reasonable period of time, the right to be free of unreasonable searches, seizures, and charges, things of that nature. So that's those all fall under the heading of the Constitution. The Constitution is a basic framework of government. It gives the federal government the power to create criminal law, the provincial government the power to prosecute it and enforce it, and it has within it the limits on government by setting out what the rights of the individual are. Now, the next component or source of criminal law is statutes. Those are the laws passed by the parliaments, the legislatures, the city halls of our country. So those are statutes, and there's a number of them that have criminal law context to them. The most notable, of course, is the Criminal Code of Canada, which sets out what the criminal laws are. However, it's not the only one. In addition, there's the Controlled Drugs and Substances Act that has to do with drugs, and it's a federal area of regulation. And that's one of the areas, actually, drug law, that when it comes to federal regulation, such as drugs and narcotics, that where the federal government enforces, and they have their own prosecution branch. We'll talk about that, the different prosecutors, a little later, but they enforce the federal regulatory statutes, the narcotics laws, the tax laws, tax code of Canada. You don't pay your taxes, federal government's coming after you looking for your tax money. The provincial government has, as I said, its own set of statutes. The Highway Traffic Act is a prominent one, the Liquor Control Act and others. And there are municipal bylaws as well, and they're a form of statute. Parking regulations, fire and safety and health regulations, things of that nature. So these statutes are all written laws passed by the legislatures or parliament, and you can find them by looking them up and saying, oh, look, it's against the law to shoot somebody, apparently. And they're written out the same way the Constitution is. And that's important because the third branch or source of criminal law is the common law. And what that means is it's precedent. It essentially is the way judges have interpreted those laws and the Constitution, because laws and constitutions, they can't possibly imagine every single scenario that might come up. And so they're set out in more or less general terms, sometimes a little more specific, sometimes a little less. And it's up to the courts to interpret what they mean as it relates to particular cases in front of them. And the idea of stare decisis, that's a Latin term that means precedent, is that if a particular law has been interpreted by the courts in a particular way before, it should continue to be interpreted that way so that everybody is operating on the same playing field. And the higher the court is in the hierarchy of courts, the more force it's got. So, for example, a court might determine, when we said that you have the right to talk to a lawyer when you're arrested within a reasonable time. Well, what's a reasonable time? Well, a reasonable time might depend on a lot of factors individual to a case, but factors that often come up in different ways, and the courts will use the decisions that were made before to figure out the case in front of it. For example, let's say you get arrested in one of our rural towns where the police presence is a lot smaller than it is in the city of Winnipeg. And there might only be 2 or 3 officers on duty at any given time. So if they arrest you and bring you back to the station house, but then get another emergency call that they have to go out on, it might be a while longer till they have someone who can sit you down with a telephone to call your lawyer than it would be, say, in the city of Winnipeg, where there's many, many police officers on duty at any given time, and there's always someone who can let you get to a phone or bring you a phone. What's reasonable might depend on the reason for the delay in getting you to a phone. For example, most courts have decided that that doesn't mean that the officers have to pull out their cell phone at the scene of a crime and let you call a lawyer there. Usually for reasons of controlling the scene of the crime and the individual, they may want to get you back to the station first and then let you call your lawyer. And for the most part, the courts have gone along with that. Now, they get you back to the station, but there's a delay, even at the station. What's reasonable? Well, let's say the case that I sort of outlined a moment ago, there's only 3 officers on duty, and they get called to the scene of a murder, or there's a fire or some other emergent thing going on, and so they delay themselves and get to getting you your phone call to a lawyer because they have to rush out to deal with the emergency. Maybe a court finds that reasonable in the circumstances and allows that delay to happen, so long as when they get back, they prioritize your getting your call to your lawyer. However, let's say the officer says, "Oh, look, it's coffee and donut time. It's my coffee break. I'm going to leave you here for 20 minutes while I go have my coffee down at the Tim's across the street." Well, probably a court's going to say that's not reasonable. That's not a reasonable excuse to delay somebody getting to speak to their lawyer about whatever they've been charged with. And that will, and once a court's ruled that way, other courts are going to follow that same precedent, so that it's not different for Frank than it is for John when they get their delays. How do you find out what precedent is in a particular case? Well, it's where lawyers come into play, or especially junior lawyers who get usually assigned to do the research by the senior lawyers. Sometimes the senior lawyers do it too. But you look up the case law, and the case law, if you have a case from the Supreme Court of Canada, well, that's pretty much dispositive of the issue. If you have it from a lower court, well, maybe it's not as persuasive, especially if a higher court somewhere else has ruled something differently. But you go down to the either the library at the University of Manitoba Law School, or in the court of the library at the courthouse, the Great Library it's called, and they have all the case law from Manitoba and from most other jurisdictions in Canada and the United States and even Great Britain and others. And you can spend many hours looking up what cases have been decided by other courts and are they relevant to your particular case or not. That's where lawyers make the big bucks on, I suppose. Okay. Next, let's talk about what makes up a crime. And there's basically 2 components to any criminal activity. And to get a conviction on a particular crime, the Crown prosecutors have to prove beyond a reasonable doubt both of those two elements of the offense. The first element is called the actus reus, Latin for the act. Person has to have done it. If we're talking about jaywalking, the person has to have jaywalked. Which I understand means walking across the street to see what's on the other side, but not at a crosswalk, but perhaps in the middle of the street. That's the act. The second component is what's called the mens rea, the intention. Person has to have intended to cross the street in the middle of the street instead of at the crosswalk. So you have to have both the act and the intention to do the act in order to get a conviction of a particular offense. Now, an example of where this might come into dispute is I've been provided with a glass of water here by Mary. It's not on screen. And you'll see me occasionally taking a drink of that water. Let's say I take a glass that turns out to be Mary's glass and not mine. Am I committing theft? Well, if the glass I've taken and deprived Mary of the use of is in fact hers, then I've done the act. That's the actus rea, taking someone else's property. Did I have the intention? Well, if her glass looks very much like mine, this is a McCafe from McDonald's glass. It looks exactly like mine. It's situated somewhere very close to mine. And I reach for it thinking that it's my glass, and it turns out not to be, then I haven't got the mens rea. I haven't got the intention to take Mary's glass. So I thought I was taking my own. It's called a mistake of fact. My intentions were innocent. I'm not going to get convicted of theft of Mary's glass of water. Let's say, though, that she has a much fancier glass than I have, and I'm jealous. So I take her glass deliberately, intending to slip it into my coat pocket and walk off with it after this webinar is over. That would be theft. I'm taking her glass, and I'm intending to take her glass because I want her glass, not mine. Mens rea and the actus rea, the act and the intention. They got me, that one. Now, there's a number of defenses to each of these, to every criminal offense. But when you boil it down, really, the defenses that come up in one way or another basically negate either the act or the intention, the actus reus or the mens rea, in some way, or perhaps even both. So let's talk for a moment about what some of these defenses might be. Well, there's the alibi defense, or didn't do it. I didn't do it. Someone else did it. I was in Toronto that day. Here's my airline ticket, here's my hotel receipt, and here's the name of 5 people who I was with when the offense was happening here in Winnipeg. That's called an alibi, or sometimes it's just an outright denial. I was there, but it was the guy in the green jacket, not the guy in the black sweater who did it. You've got the wrong guy. The second kind of defense generally goes to the mental element, the intention. I may have done it, but I didn't mean to do it. Either it was a mistake. Now that would be the example, mistake of fact. It's not a defense to say, I thought it was okay to take Mary's glass and keep it, because that's not theft. Wrong. It is theft. And a mistake of law is not a defense. A mistake of fact is. So my thinking that it was my glass, that's a defense. My thinking that stealing somebody's glass isn't against the law, that's not a defense. because everyone would say that, I suppose. There's basically not being criminally responsible, what we used to call insanity. That goes essentially to I did it, but I didn't know what I was doing, or I didn't appreciate the nature of what I was doing. And it's not my fault because I was crazy. I didn't know that I was know or able to stop myself from committing what turned out to be a criminal offense. But it's again going to the mental element, not so much saying you didn't do the physical act. Similarly, intoxication, which has limited value as a defense here, because a lot of offenses don't allow for intoxication to be a defense unless it's extreme intoxication. But that would go again to the mental element, and sometimes can diminish the responsibility of the person charged with the offense. Another defense is that it was involuntary or compulsion. In other words, no choice. I did it because somebody was holding my child hostage and saying he would shoot my son if I didn't do this. Involuntary, duress, things like that. And depending on the offense, sometimes that will provide a defense to somebody. I did it, but I didn't really have a choice. Compulsion might be something along the line of, in the jaywalking case, I didn't mean to walk on the street. Somebody else pushed me onto the street from behind as I was standing on the curb. And so although I ended up crossing the street in the middle of the street, it wasn't my fault. I didn't intend. And really, did I do it, or did the person pushing me do it? Or cause, in terms of causing what the offense happened. And then we've got self-defense. Self-defense is, I did it, but I have a legally permissible excuse for doing it. And the legally permissible excuse is self-defense. So somebody comes in with a gun and tries to shoot me, and I shoot them first. Self-defense, that is permissible. But self-defense has a lot of rules associated with it. You can't just sort of like see a threat behind every door and then act aggressively in response to that. First of all, the response you use has to be proportionate to the threat you're facing. So if you're being threatened with death, let's say, or being shot, then you're going to have a lot of leeway with using significant force to prevent that from happening. But if someone's coming at you with a loaded pillow to hit you with the pillow, and you pull out an Uzi and shoot them, then probably a court's going to find that that was not proportionate to the threat you were facing. And self-defense won't fly then. So that's one aspect of self-defense. It has to be, the force has to be proportional to the threat. Secondly, it can't be a threat that you've caused. You've pushed someone first, they come back and push you and say, oh, now you're attacking me on self-defense. Sorry, no, you started it. That's not going to allow for self-defense. If you have an avenue of escape, you're supposed to use it rather than use force to defend yourself. So if someone's coming after you with a baseball bat, but they're slow and they're in a wheelchair and they're coming slowly at you, but not really getting to you, and there's an open door that you can run out of, they're not in the way of. So yes, it may not seem like the gallant thing to do, but you're supposed to run away if you can, rather than use force to do it. Self-defense is meant to be a defense of last resort. So if you have other options, such as escaping the scene, such as using less force than shooting somebody who's coming at you with a pillow, if you started the fight and you could apologize and just get out of it that way, those are all going to be situations that you're going to have to follow, because self-defense will be negated. The last defense, we've talked about didn't do it. We've talked about did it but didn't mean to do it. We've talked about doing it but having no choice. We've talked about doing it but having an excuse. The last defense is prove it. Maybe I did it, maybe I didn't. Prove it. Maybe I intended to, maybe I didn't. Prove it. That goes to the burden of proof. The burden of proof is always on the prosecution to prove you guilty beyond a reasonable doubt. So if you're not required as a defense lawyer or defendant in a case to call any evidence or to prove yourself innocent. It's up to them to prove you guilty. Maybe they can't prove it. Maybe they don't have witnesses. Maybe their witnesses aren't very good witnesses. They weren't wearing their glasses, couldn't see what was going on. It was dark. It was the screen that you're looking at was too bright, and so I couldn't make out the details of what was going on. That's always a defense available to an accused person, is to say simply, I am not saying anything. It's up to you to prove it, prosecutor. Okay, so now we're going to talk a bit about different classes of offense. There are sort of 2.5. Basically, there's 2 with an asterisk. So the first class of offense, the serious ones, and these are all in the criminal code. The criminal code delineates what class an offense is in. First class, the more serious one, is called indictable in Canada. In the United States, what you will see in the American movies, it's called a felony. In Canada, we call it an indictable offense. And those are the more serious ones. The less serious ones in Canada are called summary conviction offenses. Again, the American legal version is to call it a misdemeanor. The asterisk, or the half of the class, is sometimes certain offenses are listed in the criminal code and in other legislative statutes as being hybrid offenses. That means that the prosecution has a choice to pursue it as either an indictable offense or a summary conviction offense, depending on a number of factors, including their view of how serious the offense is, what the person's criminal record is. If they've done it 35 times before, even if it's not so serious, they may say we're treating it as more seriously, or not. The indictable offenses carry with it a somewhat different procedure than summary conviction. Summary convictions are much more summary. They happen quicker. And part of the reason is that some offenses can range significantly in how serious they are. For example, sexual assault. Sexual assault, which when I first started law didn't exist. There were 35 or many different kinds of offenses delineated for what we now call sexual assault. But sexual assault's a very broad offense. It basically is an assault that has a sexual component to it. But what that sexual component is can be more serious or less serious. Still criminal, but different degrees of seriousness. For example, it can be anything from an uninvited touching on your bum or your breast or some other part of your body that has a sexual nature to it, all the way up to a violent, serious rape. And obviously, without poo-pooing the unwanted pinch on the rear end, the fact is there are very different levels of seriousness here, and the Crown may decide that this one falls in the summary conviction basket, this one falls in the indictable basket. Obviously, the more serious the offense, the more violent, the more harm done, the more of an invasion of your personal integrity. That's all going to lean towards indictable offense being chosen by the Crown. The less serious ones are going to lean towards summary conviction. Also, your personal history. If you've got even a less serious sexual assault, if you've done it 4 or 5 times before, Crown's going to say you've had your chance with the less serious mode. Now we're going by indictment. There's one other factor that sometimes plays a role in it, and that is what we call the statute of limitations. In Canada, there is no statute of limitations for indictable offenses. That means the fact that 35 years have passed doesn't mean we can't prosecute you anymore. That's what statute of limitations is that after so much time where you no longer have either a civil lawsuit or a criminal case against somebody because it's been too long. But in Canada, unlike the United States, in Canada, there is no statute of limitations for indictable offenses. There are statutes of limitations for summary conviction offenses, and they vary a little bit. Some of them are 6 months, some of them are as much as 2 years. They vary depending on the offense, but there is a statute of limitations. So sometimes you run into the situation where it might not be a very serious offense, one that the Crown might normally elect to go by summary conviction, but because it's been a while and the statute of limitations comes into play for summary convictions, they may say we have no choice but to go by indictable offense because we're too late given the statute of limitations for summary conviction ones. I will tell you, though, that the defense under a statute of limitations is one that has to be asserted by the defense. So the defense can waive that if they want. And sometimes agreements are made between defense and Crown that says, tell you what, go by summary conviction because the penalties are less, and we will agree not to raise the statute of limitations as a defense. It's not quite a plea bargain, but it's a bargain or an agreement that Crown and defense lawyers sometimes will make when the case is appropriate for that. Once excuse me, once you have that, the defense has to make some decisions too, and we'll talk about that in a moment. But essentially, one of the differences, well, we'll talk about it now. One of the differences is between the two offenses is the process. In an indictable offense, the defense has a number of choices to make as to mode of trial. You can choose to go straight to trial in provincial court. You can choose to go through a preliminary hearing in provincial court and then to trial in the Court of King's Bench. Or you can choose to go through a preliminary hearing in provincial court and then a trial before a judge and a jury in the Court of King's Bench. I have to keep remembering to say King's Bench now. Most of my life it's been Queen's Bench. And so those processes, there's pluses and minuses from a defense point of view. If your client, if the accused is in custody, for example, denied bail, and if they have what they feel is a strong defense, they may want to go straight to trial because they're confident in winning, and then once they win, they get out of jail. On the other hand, a lot of cases have complicated facts that need to be fleshed out. Sometimes the strength of the evidence that's coming from the Crown, witnesses in particular, isn't clear. And so preliminary hearings can help to resolve some of those issues. We're using less preliminary hearings now because of some amendments in the criminal courts, in the criminal code, rather, that have limited the use of preliminary hearings fairly recently. But where preliminary hearings are possible, they often lead to resolution of the case, because one side or the other sees the witnesses. The prosecution witnesses are particularly strong. Ooh, bad news, maybe for the defense, maybe we should be cutting a deal. Or they're not particularly good, and the Crown says, you know, I don't really have a great case here. Maybe I should be dropping this case, or offering a plea on a lesser charge. So those are considerations for both the Crown in deciding whether to go by summary conviction, which just goes straight to trial in provincial court, or by indictment, which gives the defense all these choices about how to go to trial. Okay, let's now talk about the various people in the criminal law system. Here's Mary's water. Getting a drink of. So, first of all, there's the prosecutors. They're lawyers. Yes, they are. They're lawyers who happen to work for the government and want to put people in jail or prosecute people. They are, where I sit, they're the enemy. They're not really the enemy, but they are in charge of prosecuting, and they are the ones who present evidence and have to prove beyond a reasonable doubt the guilt of an accused, the commission of a crime, and the commission by the particular accused who's before the court. And then there's the defense lawyers. I'm one of those. We represent the person or persons charged with the offense. Now, I'm going to stop for a moment and tell you that the responsibilities, although both Crown and defense, we all went to law school together, and sometimes some of the Crown attorneys used to be defense lawyers and some of the defense lawyers used to be Crown attorneys. We in Manitoba generally only act on one side or the other, but we have very different responsibilities in a criminal law setting. Defense lawyers are there to represent their client, the accused. And they are there, they're not there for the benefit of society as a whole, except in a philosophical way. They're there to represent the interests of their client within the parameters of the law. There are limits we're not allowed to cross. For example, we're not allowed to knowingly call false evidence. If we know somebody is going to take the stand and lie, we're not allowed to put them on the stand, except for the accused. But if the accused, for example, wants you to call his friend Bobby, who's going to say he was in Calgary when the offense was committed in Winnipeg, alibi, if you were keeping track. And we know that Bobby's going to say, yeah, I wasn't there, but I'm willing to say whatever to help my friend out. We can't put him on the stand. We can't knowingly call false evidence. We can't destroy evidence. Now, it's not our job to call attention to negative evidence for our client. If we happen to know that, for example, the weapon used in the offense has been dumped into the Red River just near the Redwood Bridge, no responsibility on us to go tell the police or the prosecution, that's where you're going to find the weapon. We can't move it. We can't hide it. We can't get rid of it, but we don't have to tell them about it. The Crown has a very different responsibility, because the Crown is there not to represent the victim. Sometimes that's what the victims think, and the odd junior Crown too. But they're there to represent society as a whole. That society as a whole happens to include the accused person. So if the Crown attorney, for example, knows of evidence that tends to exonerate the accused person, the crown attorney's duty is to make that known to the defense and to call that evidence if need be, because they're there for truth, justice, and the Canadian way, and society as a whole. The defense, if we know of evidence that would tend to incriminate the accused, we've got no responsibility to bring that forward because we're there for the accused, not for society as a whole. Although one might argue that the existence of defense lawyers benefits society in general. So very different responsibilities between Crown and defense lawyers. Okay, we have the complainant. The complainant is the victim. Now, sometimes the complainant is obvious. If Frank hits John, Frank is the accused, person who's charged with the offense. John is the victim, the complainant. Sometimes it's not as obvious. For example, if you violating a noise bylaw in the middle of the night, who are the victims? Well, maybe it's all the neighbors in the area, although go round them all up and try and get statements from them. Maybe it's just the queen or the king now. Sorry, the king. If you jaywalk and there's no one around except the police officer who sees it and then arrests you and gives you a ticket. So who's the victim? You're not holding up traffic. Well, the victim is the king, because it's his laws that are being disobeyed and broken. And so that's why you'll see what we call the style of cause, or the name of the case is in criminal law is always the king, or was the queen, against the person who's alleged to have broken the law. They are all the king and the queen. They're really, what we're talking about is the government of the country and or the province. They are the people who run the case against the accused. You'll never see the victim's name there as a party to the offense, because they're not a party. It's the government against the person who's broken law. I was going to say individual, but I guess it could be a corporation as well. Okay. Now, we've talked about the accused and the complainant. There are also the police. The police, their job is to investigate crime and to solve crimes and produce what they think are the perpetrators. But they are also, at least in theory, they're expected to be neutral. They carry out their investigations neutrally, looking for who really did it and was there really a crime here. And they're not, when they come to court to give their evidence, they're supposed to give it in a fair and neutral manner. Don't always follow that rule, human beings being what they are, but that's what the expectation is. They're there to establish as best they can through investigation what the facts are. Now, once you've got someone charged and the question of bail comes up, and one of the things that can come up in bail is having what's called a surety. A surety is someone who's going to, in effect, vouch for the accused that they will show up to court when they're supposed to and won't jump on the nearest plane to Brazil or somewhere and not come back. Surety usually either puts up money or signs as a surety on a recognizance, on a bail order that says, if and when Johnny doesn't come to court when he's supposed to, I agree that I'm going to be held liable for $1,000 or $5,000 or whatever amount the judge says. And their job is to supervise the accused while he's out on bail or she's out on bail and make sure that they get to court when they're supposed to be there. Okay, we have in court, I referred to the fact that there are the possibility of a judge and a jury. So a judge, they're the ones who, when they sit by themselves and hear a case, they decide both what happened based on the evidence that's presented before them. So they decide the facts, and then they apply the appropriate law to those facts to come up with a verdict of either guilty or not guilty. When there's a jury involved, then you have split responsibilities. The jury decides based on the evidence that's presented what the facts are. The judge instructs the jury as to what the law is. So let's say you have a case where the argument is about self-defense. The judge will explain to the jury what some of the things we talked about self-defense, and say to the jury, if you find that the force used by the accused was reasonable in the circumstance, and that there was no chance of escape and so on and so forth, then you should acquit. If you find that it was a disproportionate force, or that the accused had a chance to escape the situation and didn't avail themselves of that chance, then you should convict. And then the jury takes that and decides, based on the evidence that they heard, which it is. Now, I see, Nina, there's a question that's come up. Do you want to stop and try and deal with that?
Yeah, somebody was just asking whether the recorded version will be available or sent to the participants. So I've just gone ahead and answered that in the chat. So you can feel free to continue.
You've got your answer from someone who knows more about that than I do. Okay, let's go on. I just get notification that there is a question, and not what the actual question is. Okay, so those are the differences between a judge and a jury. The judge tells them what the law is, and the jury decides what the facts are and how they relate to that law. The witnesses, they're there just to give us the facts, ma'am. Tell what they saw. There are all sorts of rules. We're not going to do the whole law of evidence today, but there's rules about hearsay. Don't tell me what someone else told you. Just tell me what you saw, what you heard, what you did, perhaps. And so that is where the witnesses come in. And they're obviously, again, like the police, they're expected to give an honest version of what occurred. And of course, they're going to be subjected to cross-examination by one side or the other, by the side that didn't call them, generally, to test whether they've forgotten to say something, or haven't filled out what the circumstances. It was a very foggy day, so how could you see 100 yards away what was happening? That sort of thing. Or whether there was a defense, especially if it was the complainant giving evidence. So did you hit him first? And was he hitting you just because you hit him, for example? Try and do it a little bit better than that in court, but you get the idea. Okay, now we're going to take a moment to talk about what the various courts in the province of Manitoba are, and beyond, because you can go to the Supreme Court. And basically, when it comes to criminal law, we have 4 levels of court that can come into play. The first level, with all due respect, the lowest level, is the provincial court. And I say that with all due respect because they actually hear the vast majority of criminal cases. Most cases never get beyond the provincial court. But the provincial court is a specialized court dealing with criminal law. They don't deal with divorce. They don't deal with civil lawsuits. They deal just with criminal law. That's an oversimplification, because in some rural jurisdictions they do some family law, but basically their job is criminal law. They will hear most bail applications. They will hear most of the sentencings that go on when someone pleads guilty and it's a plea bargain, and they will hear summary conviction trials, all of them, and they will hear many of the indictable offense trials when the defense chooses to go straight to trial in provincial court. As I said earlier, sometimes people will choose them to have the trial simply because someone's in custody, or they have some good reason why they want to deal with it as fast as they possibly can. Sometimes, because giving away a secret of the trade, that it's sometimes felt that if there's a case where the facts are going to be kind of ugly for your client, because provincial court hears a lot more criminal cases than any other level of court, they're going to be less influenced by emotion and by ugly facts, and give you a better hearing. And so sometimes the defense will choose to, or elect to, go to trial in provincial court, even if they have the chance to go elsewhere, to Court of King's Bench or for their trial in front of a judge alone, or a judge and jury. In provincial court, there's no jury trials. There's just a judge. The judge is appointed by the provincial government. And they also hear all the preliminary hearings, and, as I said, many of the trials and sentences. The next level up is the Court of King's Bench. That's the judges are appointed by the federal government, and they hear indictable offenses where the accused has elected trial in King's Bench by judge alone, or trial in King's Bench with a judge and jury. They also hear appeals of summary conviction cases from the provincial court. The court above them is the Manitoba Court of Appeal. They hear appeals from the Court of King's Bench, but also from the provincial court, where the provincial court has had a case go before it that is indictable. So where an accused is elected indictment, where it's an indictable case, either because it's defined as indictable or the Crown has elected indictment, but where the accused has elected trial on an indictable matter in provincial court, the appeal goes to the Court of Appeal and not to the Queen's Bench. It goes to the King's Bench. It goes to the King's Bench only when it's a summary conviction matter. Appeals to the Court of Appeal from the defense have to be based on arguing that the judge in the case, in the trial, made a mistake of law, or a mistake of mixed fact and law. There has to be a legal element to the appeal. It can't be just that he believed Johnny and not Frank, and I don't like that because I'm Johnny. There has to be a question of law involved to go for an appeal to be heard by the Court of Appeal. Now, it can be, if from the defense side, it can be a question of what we call mixed law and fact, where the facts are interpreted in such a way that is not in line with what the law is on how they should be done. There still has to be an element of legal mistake being argued, but it can be tied into the findings of fact. The Crown has a little bit harder of a job, is that they can only appeal questions of law or mistakes of law. They say the judge has made a mistake in the law that was applicable, either in admitting evidence, for example, where that's contested, or in applying the law in reaching a verdict. The final level of appeal goes to the Supreme Court of Canada. And again, that can only be on a question of law alone. Supreme Court doesn't hear a lot of cases. They have to get permission from the Supreme Court for them to hear your case. Usually one of the judges will hear arguments and what the case is about and try to decide if the question of law involved is one of significance to the whole country, national significance, or where there's cases from different court of appeals that clash with each other, and those clashes should be resolved. So if the Saskatchewan Court of Appeal has said black and the Ontario Court of Appeal has said white, and they want to resolve it one way or the other, then the Supreme Court can hear that kind of a case as well. Now let's take you through the process of what happens when someone gets arrested to the end. So the first step is once somebody is arrested and charged with an offense, the first question that comes up is, are they going to be in custody till the case is resolved, or are they going to be released on bail, or what we call it in the criminal code, judicial interim release? That's bail. And the burden of proof is on the Crown to show that the accused should be kept in custody. Otherwise, the accused is going to be released on some form of bail. There are 3 grounds that the Crown can argue to keep a person in custody. The primary ground, the first ground, is that they're not going to show up for their trial. They're going to run off. And usually what they will argue is that, look, the fellow's been charged 35 times before with failing to appear in court when they were supposed to. Yes, that's an offense. Breaking your bail is an offense. And so we have every reason to believe that if you release them on bail, they won't show up again. And if they convince the judge that's the case, it's the end of the discussion, and the bail can be denied. The secondary ground has more to do with whether there's going to be a continuation or repetition of the offense. So if a person is charged with break, enter, and theft, and has a record for 14 other break, enters, and theft, especially if they're recent, there's a pretty good chance they're going to get denied bail. Similarly, if a fellow has been charged, let's say, in a domestic assault, and they get released on bail with a condition to have no contact with the victim, usually their spouse, and as soon as they get out of jail, on bail, they go to the spouse and say, I'm going to get you for calling the police on me, or something like that, or perhaps trying to convince them to not go ahead, to withdraw the complaint. And spouse or neighbor or somebody calls the police and they get arrested again, well, their chances of getting out on bail just a second time are not as good. And if there's a third time, not likely, but you never know. The third ground is that, and it's reserved really for the most extreme cases, is that it would be really contrary to the public interest to release someone. And those come up in like organized crime or terrorism type cases. They don't generally come up in sort of your everyday cases. It's a pretty rare case where the Crown relies on the tertiary or third ground for bail to try and argue against bail. But again, the benefit of the doubt goes to the accused when we're engaged in a contested bail hearing and trying to get someone out, and the Crown's opposed. The Crown often doesn't even oppose bail if they're satisfied that it's an appropriate case, and then person's released a lot more easily. Sometimes they're released directly by the police on what's called a promise to appear. The police have the ability to release you on conditions, usually getting fingerprinted, photographed, staying away from the victim, that sort of thing. And then if they don't release you, then you get to go to provincial court to try and get bail set there. Okay, once you've got bail or you've been denied bail, the next step is to go to the docket courts, the first of which is an intake docket. That's basically an organizational court where people go to make sure they've got a lawyer, if they haven't had a chance to get one, to if they are applying for legal aid, that the legal aid application gets processed. Once the lawyer's on the case, the lawyer is going to ask the prosecution to provide them with what we call particulars, and what that is, that's the details and the evidence of the case. Usually, it's at least to begin with will be the police notes and summary of what occurred, and any statements that were taken from witnesses or from the accused if he gave a statement or she gave a statement. And so that court is there to sort of function, keep the case alive while the particulars are processed, given to the defense. The defense has a chance to look at them, to review them with their client, have a discussion or two with the prosecution, or they have a prosecutor assigned to the case and look at it. It's an organizational docket. When that's finished, when that process is finished, the next step is to set court hearing dates. And that can be done through what we now call the intake or triage courts. Usually what happens is the prosecution, the prosecutor assigned to the case will request some dates, available dates from the court, present them to the defense after deleting the ones that aren't good for them. The defense will look at it and say, well, I'm not good for this date, I'm not good for that date, Michael, not that one, but these three are good for us. And a date will be set upon. And the accused will sign paperwork to say, acknowledge that that's the date, and the date gets set. Okay. In cases that are going to last more than a day, basically, the next step would be to go to a case management conference. It's a case where you meet with the prosecutor and the defense lawyer and a judge who's assigned to manage the case, but not hear the case at the end of the day. Get to sit down, go through if there's and decide how the case is going to go forward, how the trial is going to happen. First of all, has the defense received all the particulars, all the disclosure that they're entitled to? What's missing? Will you get that for them within the next 3 weeks or what have you? They'll also talk about the case and if there are any preliminary legal issues that need to be dealt with. Is there going to be, if there's a statement from the accused, is there going to be something called a voir dire, which means it's French for see before you say it, which basically means a little trial within a trial to see if a particular piece of evidence or a statement is admissible evidence or not. If let's say a statement's taken from an accused person without them being told they have the right to remain silent or to speak to a lawyer, it may not be an admissible case, a statement rather, or if there's been an illegal search, an unreasonable search, and there may be a hearing to hear if that violates their accused charter rights and whether that evidence should be excluded or not. So they try and sort out whether those are coming down the road so that they can book an appropriate period of time and set a timeline and things like that. The judge will also sometimes give an opinion that says, based on everything I've been told about the case, defense, I think you're going to have a hard time beating this charge. Crown, you're going to have a hard time proving that one. Why? Maybe you want to think about making a deal or not. And that actually can be fairly useful in sort of hearing what one judge's opinion is on it, because not every judge thinks the same way, but it's good to have that input, and sometimes helps lead to resolutions of the case. Okay, if the case goes forward, as I've said before, sometimes there's a preliminary hearing, and if it's an indictable case, and in a preliminary hearing, the burden of proof actually switches a bit. The Crown does not have to calls evidence, but they don't call evidence to prove the case beyond a reasonable doubt. They just have to call enough evidence to show that if this evidence were to be believed, would they have made out the elements of a case that the judge could then later, judge or the jury could later then decide whether they believe it or not believe it, and how much weight to give it to. So the burden on the Crown at a preliminary hearing is really quite small. They just have to call enough evidence that says this evidence shows that if you believe the witness that the accused person hit her, there was no case of self-defense or mistake, that just sort of a very general, if you were to believe them, you don't have to believe them, but if you were to believe this evidence, the Crown has a prima facie case, enough to make it go to trial. At the trial, whether it's in provincial court or King's Bench, it's a bit different, because then the evidence has to be persuasive beyond a reasonable doubt in order to secure a conviction. I might also say that at preliminary hearings, although the preliminary hearing judges cannot decide charter challenges, but it's useful to get out the facts and get an idea of what the facts are and what the evidence is if you're going to have a charter challenge later. For example, questioning a police officer as to whether they read the accused his rights before he made that statement. That might be something, or whether what the reasonable grounds for doing the search was. You may not be able to get the evidence excluded at the preliminary hearing, but you're setting the basis for making an argument that it should be excluded at trial. Okay, if let's say the accused is lucky enough to get acquitted, they go home at the trial, after the trial. If they're not, if they're convicted, then the next step is sentencing. Now, sentencing is interesting because you've now been you could have pled guilty at any point along the way, or you could have been found guilty at a trial. If you've pled guilty, then you might be pleading guilty to doing the offense, but not to many of the circumstances that might be aggravating along the way. You might, for an assault case, you might say, I punched him once, not 3 times. Or I didn't hit him that hard, or something of that nature. You may also have some what we call mitigating things that make it less serious, such as, well, he provoked me. He called me names and said bad things about my mother, and that's why I hit him. Now, usually in most sentencing hearings, evidence is not actually called. If there's been a trial, of course, the judge has heard the evidence from the trial. But essentially, the benefit of the doubt continues to go with the accused. So if there's a question, for example, of did he punch him 3 times or did he punch him twice or once, either the prosecution has to call evidence to prove how many times the person was punched, or the defense's version gets accepted, so long as the defense version doesn't deny the offense as a whole. The defense is entitled to the benefit of the doubt, unless there's evidence called that proves beyond a reasonable doubt the Crown's version. Now, again, whoever doesn't like the results, whether it's of the sentence or of the verdict, they have the right to appeal, and you can appeal both the conviction and the sentence if you're to the defense, or you can just say, okay, I don't have grounds to appeal the verdict. I don't have legal grounds to appeal the verdict, but sentencing is always a legal question that is open to appeal. And so you can appeal the sentence without necessarily appealing the verdict, or you can appeal both. and so can the Crown. And again, these usually are on questions of law. The principles of sentencing include essentially a balancing between imposing the sentence that imposes the least possible restrictions or punishment on the accused that's consistent with fundamental justice principles such as holding the accused responsible for their actions, serving as deterrent both to the accused person and to society as a whole. Other people who hear that if you beat up a person for no good reason, you're going to go to jail, maybe they'll be deterred from beating up other people. And so there's a balancing, and then there's the question of, has this person been rehabilitated? Are they rehabilitatable? It's a first offense. They were drinking. They've gone to AA, and they've stopped drinking. They're rehabilitated. That might lower the need to sentence harshly. So these all go into the judge's considerations. That he or she balances off the proportionality of denunciation of the bad offenses, the need to deter the individual and others from doing this again, and on the other side, rehabilitation and the least possible sentence that accomplishes all those goals gets imposed. Now, the kinds of sentences that can be imposed range from what's called a discharge. A discharge means you're guilty, but you're not going to get a criminal record for it. And sometimes there can be conditions. It can be an absolute discharge, go home, live long and prosper. Or it can be, I'm putting you on a conditional discharge for a year. If you stay out of trouble, if you make restitution, if you take this course, whatever the conditions the judge thinks is appropriate, do community service work, then at the end of that year, you won't have a criminal record. Next step up from discharges is suspended sentence. That can include probation or not. Suspended sentences, I'm the judge saying, I'm not going to pass sentence on you today. And if you stay out of trouble for the next 2 years, I'll never pass sentence on you. Essentially, I'm suspending the passing of sentence on you for 2 years, and nothing more will happen. Or there could be conditions usually associated with a probation order, which we'll talk about in a moment. And I won't sentence you to anything further, although you do get a criminal record for that. It's different from what the Americans call a suspension sentence, in that if a 2-year suspended sentence in the United States is that if you do something, then you've got 2 years. That's your sentence. Whereas here, it's the passing of sentence will happen. It won't happen if you're good for 2 years. But if you get in trouble again, we can pass sentence on you again. I'm getting the 10-minute warning now.
10-minute warning, that's right.
Okay,
and if
great.
anyone does have any questions for the end of the webinar, feel free to put them in the chat or in the Q&A now.
Great. We're going to actually make it, I think. Okay. Probation, there's probation officers. They're people who are trained in this. Often they're social workers, although they don't have to be. They supervise probation, and that's usually conditions where for a year or 2 years or something in between, you have to do certain things. Maybe you have a curfew. Maybe you have to do community service work, and they will supervise you and help you to do that. Maybe you need to take a program of some kind for alcoholism, for drug use, or what have you. Or maybe it's just stay out of trouble and report to me once a month or once a week or once every, whatever they decide. There are fines. Those are financial penalties. You pay $1,000 as your punishment or what have you. And then there's jail. Jail is obviously the most extreme penalty. We don't have capital punishment in Canada. And so jail can be, if it's less than 2 years in a provincial facility, such as Headingley Correctional Institute in Manitoba, or if it's more than 2 years, it's in a penitentiary, such as Stony Mountain Penitentiary. We also have what's called conditional sentences. These are effectively jail sentences that you serve in the community, usually at home. And they're somewhat like the American version of suspended sentences in that as long as you follow the conditions, and some of them are pretty restrictive. They usually involve curfews and supervision by a sentence supervisor. It's really just a probation officer, again, what they call a sentence supervisor. And you serve your sentence that way with a bunch of restrictions on you, but you get to do it out of your own home. If you violate that, like in the American suspended sentence, you then go to real jail for whatever's left of the sentence. Some of the things that get done in helping judges decide what the sentence would be is sometimes they will ask for a pre-sentence report. That's a probation officer interviews the accused, interviews the victim. Maybe there's a victim impact statement made. They interview people who know the accused. They're basically trying to put together a picture for the judge of who the accused is. Is it someone who made a bad decision once, or is it someone who's continuously making bad decisions and getting in trouble and requires more than just a little bit of help and a warning type of thing? We have in Canada what's called the Gladue decision. That's a decision of the Supreme Court that says that when it comes to Indigenous offenders, that the effects of growing up in a colonialist society and residential schools where that's happened and all the fallout that living in Canada as an Indigenous person, that can have an impact on why they've come into committing a criminal offense, and that should be taken into account in sentencing. And it is, although often it's not enough to keep them out of jail if the offense is serious enough. But it's something that gives the judge information that can allow the judge to assess whether that creates mitigating circumstances that is worthy of maybe a lower sentence than would otherwise be the case. There are some alternatives, some that are sometimes used to resolve cases, usually where the accused person doesn't have a long record and can be helped by it. Mediation, healing circles, diversion cases, pay restitution, take an anger management course, and we'll let you escape without a criminal record type of things. Restorative justice is also, these are all factors that help in appropriate cases to move the case out of the strict criminal law system into something else that's maybe more constructive and more helpful in keeping you from being back sometime in the future. Okay, we're beginning to run out of time. I'm just going to check with Nina for a moment. Are there any questions from our
nothing from the audience, but I do have a couple of questions if nobody else does. But otherwise, if you have some more material to get through, then feel free.
That's basically it. I guess I could talk very quickly about legal aid. Everybody's entitled to a lawyer in Manitoba, regardless of their ability to pay. So we have Legal Aid Manitoba. Legal Aid will pay for your lawyer if you meet their financial requirements, which show that you can't afford a lawyer on your own. They have duty counsel, who are lawyers who are assigned to particular courtrooms and can help you out in the short term. before a formal lawyer is appointed to run a trial for you, for example. Private lawyers like myself often take legal aid cases. Means legal aid pays us. You don't, although if you're sort of borderline on their financial scale, you may have to pay them back for what they pay us, but you're getting our services at a far reduced rate because legal aid doesn't pay us nearly as much as private retainers do. So legal aid is there to ensure that everybody has access to a lawyer when they're facing most criminal charges. I don't think they don't generally appoint for Highway Traffic Act or things like that at the very bottom of the scale. But anything that involves getting a criminal record that's going to impact your livelihood or send you to jail, they'll or potentially send you to jail. They will help you assign a lawyer, either a staff lawyer or a private bar lawyer who's willing to take legal aid cases. And if you have a lawyer in mind, assuming that lawyer takes legal aid cases, they'll let you choose that lawyer. Okay, ready for the questions.
Okay, so I have a couple of questions for you. So you mentioned the right against self-incrimination and the fact that an accused can't be forced to testify at their trial. As a defense lawyer, are there times that you might go against that and get your client to testify? And if so, what sorts of things do you take into consideration when making a decision like that?
Absolutely, there are times when you usually you want, but you usually have to put your client on the stand. That would often several situations, but usually it's where you feel that if you don't put your client on the stand, you're going to lose. That simple. Sometimes the Crown has called a case where, and sometimes they're very similar. One witness case where the other person says, he hit me, and you have to then take the stand to say, no, I didn't, because there's no other evidence out there. Now, if the evidence in the first place is kind of, I think he hit me, someone hit me, I thought it was him, then maybe you don't have to take the stand. But quite often in cases, the Crown makes at least enough of a case out there that if you don't give your side of the story, explaining your side and presenting your defense to it, then you're going to lose. So at that point, you really have to take the stand. There are times, for example, where that you're going to have to present evidence. If often in an alibi case, if you don't take the stand to say I was in Toronto when this happened, no one else will, so it won't be there. It's very much a case-by-case decision, but frankly, it's not that unusual as it's sometimes. The stereotype is that lawyers never put their clients on the stand if they can avoid it. And although that may be true in theory, the fact is that cases at that point that go to trial often really cry out for your client to give his or her side of the story if you're going to be successful.
I have one more question here. Somebody is asking if you can briefly touch on restorative justice measures. I know that that can be a big topic, but is there anything that you can sort of say about that?
It's a very long topic because there's a lot of them. But they're the idea behind them, and usually these are with people who where it's shown to be of some benefit. Usually people who don't have long criminal records or very serious attacks upon people. But examples of it would be a healing circle, which sometimes happens. It's usually with Indigenous offenders, where talking it out can and accepting responsibility and exchanging views of what happened could be part of it. Restorative can be something mediation. It would be an example of a restorative thing where essentially you try and make the victim whole as well, and because they're participants in it, as well as giving the accused some assistance too. It would not be used where someone is maintaining their innocence strongly, because if you didn't do it, you didn't do it, right? but there are circumstances where either because they're neighbors or family or people are involved, or it's just a case that seems to be appropriate for it, where some maybe restitution or attending a mediation or a healing circle or some sort of a apology or something along those lines is appropriate. I'm giving you only the very basics. There's a lot more that can be done. I've been to conferences, whole conferences where they talk about nothing but that's the gist of it.
Yeah, it's definitely a very big topic. I have one more question here for you, and then maybe we'll wrap up here. So I'm just wondering if you can talk a little bit about what someone can expect when they meet with a criminal defense lawyer for the first time. Are there things that maybe they should or shouldn't tell them, or certain questions that they should ask?
Well, okay. Should or shouldn't tell them. The lawyer will usually sort of guide the first meeting along. My practice is I start by getting your basic background. What's your name? Where do you live? Contact information. Are you married? Do you have kids? Are you divorced? Get just a general sense of who you are, and then okay. So what you're charged with? This. Give me sort of the Reader's Digest version of what happened. I know, again, there's stories out there of stereotypes that lawyers say, well, I don't want to know what happened. I'll just get to it. I actually do want to know what happened because it helps me figure out what the best route is, although I'll never make a decision or give you serious advice on it until after I've seen the police reports, which is later in the process. But to get an idea of what the issues are, it's a good starting point. Usually we don't get the police reports till we actually get to court, which might be a couple months after the first meeting, a couple months after the arrest. That's just the backlog. Now, from a client's perspective or an accused person's perspective, what you want to get out of the lawyer is just a sense of who that lawyer is. Do they have experience in criminal law? How long? And just a sense of, is this someone I can work with? Now, of course, the other thing you want to know, especially, is if you're planning on applying for legal aid, is this a lawyer who takes legal aid cases? If you're not applying for legal aid, how much is it going to cost me? Now, in criminal cases where we're not talking legal aid, lawyers charge by the hour, and every lawyer has an hourly rate. It can be from a very junior lawyer, might only be $150 an hour. From a very senior lawyer, it might be $500 or $600 an hour, and everything in between. It somewhat depends on the lawyer's seniority, how long they've been at it. Although that's not the be all and end all, it also might depend on the lawyer's overhead. So a lot of criminal lawyers in particular either work on their own or in smaller firms, and maybe their overhead's less, so they get to charge you less. Whereas lawyers with bigger firms, with big offices at Portage and Main, their rent is higher, they're going to have to charge you more. Although many of those don't practice in the area of criminal law, to be honest. But you're going to want to know as a potential client and the lawyer won't be able to tell you exactly what it's going to charge you because we don't know ourselves. Is this going to be a case that settles very quickly? Is it going to go all the way to the bitter end of trial, or somewhere in between? But we can give you what our hourly rate is, and we can give you a sort of a general sense that if it settles right, if it's a case that looks like it's going to get be appropriate for diversion, and it's only a couple court appearances, it might settle for $2,000, $3,000 in fees, whereas if it goes to trial, it might be $30,000 in fees. We can give you that sort of general idea, but every case is different, and the lawyer himself or herself isn't really going to know how much time it's going to go. It's going to take until it happens, because if, let's say, let's say there's an offer on the table, a plea bargain offer. The lawyer says to you, I think you should take it. This is a not bad offer. And you say, no, I don't want to, I want to fight it. The lawyer might warn you. The lawyer might take written instructions saying, I told you to take the deal, but you don't want to. Sign here. Let's cover our rear ends. But obviously that's going to cost you more too, because you're taking up more of the lawyer's time. So, but you're going to want to know that. And you're going to want to know what about a retainer. What a retainer is, it's like a deposit. You take money up because if you buy a TV and then on credit and you don't pay for it, they come and take the TV away. The lawyer can't come and take your acquittal away once you've got it. So the lawyer will want the money up front and it goes into a trust account governed by the losses or under Law Society rules and supervision. So most lawyers are way too chicken to try and breach any of those rules. And then they may pay themselves out of it after issuing bills at points along the way. Some lawyers do it once a month. Some lawyers do it after significant events in the case. So you're going to want to know what that is all about. How and you know, sometimes people are uncomfortable talking about money, but you have to understand, lawyers, this is how we earn our living and support our families, and you have to know what you're getting into financially before you sign on with a lawyer. So that would be an important thing to ask and to talk about in the first meeting with a lawyer.
Yeah, that's a great answer. Okay, so we've gone a little bit over here. Somebody in the Q&A is saying, thank you for this informative presentation. Not being a legal professional, I appreciate how accessible the information was presented. And I would just like to echo that sentiment. We appreciate you being here today and talking about criminal law. It was a very informative and thorough presentation. I hope that everybody got something out of it and learned something new. And that being said, I guess I will let everybody go for the night. Thank you all so much for being here, for attending, and I hope everybody has a wonderful rest of the week. And we will see you at our next one.
Good night, everybody. I'm just going to finish off Mary's water.
Have a good night.
Good night.